the first to know Nsem-Pii TV.
Deputy Attorney General Alfred Tua Yeboah lawyer Eddie Nsem kakra atudwa wachechire nsem regarding James Quayson case we okasafa nana Dormaahene sermon aye the judicial council last sermon and after okasafa case at Forson and after Alhaji Collins Dauda matuesie just a host of other cases are doctors nyina eda Attorney General abem yedi kan na o chirechire James Quayson nsensem mu ekwanya lawyer chachikata afaso na odi application here application there stay of proceeding near Batwogu appeals court or stay of proceeding Supreme Court near Batwogu me file application we me file application we chira Alfred Tua Yeboah chirechire nsem se ni jira na wa wiye though the law allows for such stages but ni jira wa wiye odi chiremu kakra ba obi ana wo chiremu the NDC minority group in parliament and amonto omonso start omutu say brebia no a masin of myself James Quayson ebeko court to be an boycott to parliamentary duties na omo akoma no a helping hand e omo friend solidarity in support for the assin of MP and also no yera Alfred Tua Yeboah echechire obi ana wo echechire mu mu Ghana for nsensem bi omo kasa an ya to aba e de ama James Quayson e wie e kire say the good people of assin of epena asem omodono enti die enti ena esese yekoswa na ye try no for those criminal charges ya ye de ataretare no ebi so kura chiri mu say the daily trial of James Quayson ya dia e be affecting in duties as a member of parliament representing the good people of Asenof because there be omra court any pay so yakoba election ama the good people of Asenof atwaba e de yi no as the parliamentary candidate for the area. There be omra court to a better what to me are discharging the duties well as a member of parliament. Just ensem bebrebe and any bebrebe na omo enka e dia fa this James Quayson case ya empo ya sha sia cross examination koso entino Deputy Attorney General Alfred Tua Yeboah sorry echechiremu kakra odema edifa James Quayson e case no ye wi a ye beba da ya baba beto akoma.
Yes, this particular matter it started in January 2022, so it's been 1 year 7 months. And if you have a case in court 1 year 7 months and you have only the first witness being cross-examined, then it tells you how the case has delayed. Now the court made a ruling that it may want to have the matter heard day to day. If a court makes an order and disagree, you have the right to appeal against that order. And I think that Quayson and his lawyers, they are of the opinion that the judge erred in making that order. We disagree with them. You go to court and they file a process seeking to challenge that order. You have no option than to also respond for the court to give its ruling. So it is true that for the past 1 month, actually, you've not done much, all because of this, or what some of us would say, legal gymnastics. You may want to take advantage of a certain law, which is permitted. We have to also meet. For example, we're in court today, there was another application, we responded and they lost. If you go to court on Friday and they find another one, we have to also respond to them. But you do all those things, you get to a point where you end. And so we are unfaced. But generally, if you take murder cases, they are tried by a judge and 7 jurors. All of them are present at the same time for proceedings to commence. And so if you go to court and one of the jurors is bereaved, is sick, has traveled, it means that you have to take an adjournment. So when it comes to the trial of those cases, it means a lot. In the advanced world, because of their system, when they're able to do everything, they say, for example, 2 weeks, the jurors are kept, the matter is heard, and judgment delivered. But in Ghana, that's not because of financial difficulties. So that's the reason why if you take those first-degree felony cases, it takes a whole lot of time. Even if you are trying the case, in murder cases, and before you even finish the matter, maybe you've taken evidence from prosecution, they've closed their case, the accused person has testified, the court has even summed up the evidence, and one of the jurors passes on, you have to start de novo, start afresh. So that's a case in a different realm. But if you take second-degree felony like stealing, causing financial loss, perjury, those offenses are tried by one judge. So that judge is able to have time to hear the matter expeditiously, unless he's sick or he's been transferred. So that's the difference between this particular case and those high-profile.
What about the Opuni case?
Opuni, how many years now? 2018. The state has called, if I'm not mistaken, the state called over 11 witnesses. And Opuni, you have about 4 accused persons. Each accused person has a lawyer. He has the right to cross-examine one person. So, for example, you take witness A into the box. Counsel for Mr. Opuni will cross-examine him. Counsel for Mr. Sedu Agongo will cross-examine. Even the company, Agricourt, will also cross-examine. So it takes a whole lot of time to do it. So anytime that you are prosecuting multiple accused persons, it takes a lot of time.
So what is the public interest benefit of trying Judge Quayson every day?
You see, if you take Judge Quayson's case, he's not the only accused person whose case is being tried daily. If you go to the court, I may want you to maybe do that kind of investigations. If you go to the high courts, you get many cases where the accused persons go to court daily. Because when you start the trial, the case can be pending for a year. We've not started the hearing. But when you start the hearing, most of the judges may want to hear the cases expeditiously, but subject to availability of time within their calendar. So if you are fortunate to have a judge whose court has a lot of time to spare, and he says, I'm ready.
But he is an MP. So he must balance public policy because he is a member of parliament duly elected. So if you are saying you should try the case daily, and Parliament sits 4 days a week, sometimes 5 days, you know that you are depriving his constituents of representation. You cannot be oblivious to that.
But you see, the farmer who is also being tried, the farmer, or the teacher who is also in the classroom, or the accountant who is working in another office, are they also not workers?
Yeah, but that's why when a member of parliament is on his way to parliament, sometimes he's protected from even arrest because the duty of MP is not the same. You cannot equate all the duties. So yes, everybody's job is important, but the law makes provision for lawmakers because of the sensitive nature of the job they do.
It's true. You started the example of the MP going to parliament. He can be arrested. He cannot be served with a process seeking to arrest him. Meaning the person cannot be served with a warrant that we under arrest. But the police officer on the spur of the moment can arrest him because arrest is either by a warrant or without a warrant. So if you look at that provision so well, we realize that it is not true that an MP cannot be arrested on his way to parliament because there must be a process being served on that MP. And the police may not serve any process. So for example, you're in traffic and you pull your pistol and shoot someone as an MP. So the police will have to wait for you. So you are going to...
Na after the boa tia ewie na wo to aso e de afa na Dormaahene comment a make here emre bi during the John Evans Atanos Memorial Lecture. And na Dormaahene din sem kakra ko tu dwa say the Attorney General or also filing for null prosequi of the James Quayson case. Na wono kra no say oka Supreme Court judges no wan ka obekọ to the opposite side. Keka Nsem-Pii. Now, what you say the Judicial Council and after the Ghana Legal Council at Wamonsa at the Afre Nana Dormaahene or Sajifo or Sadia Yajimabedu, ya or sign a high court judge. Say Omra. Now, Omeyi the one with respect to the commenter or passe edify the James Quayson criminal trial. Edipabi Esusu say, in fact, the Casa Wakayano and Chayi crack. Now, after the sermon by the Judicial Council and the Ghana Judicial Council, the NDC through Omo General Secretary Fifi Yavikwete, at a crata Bechimusa I said, yeah, some of Coso El Quarter, independent to me, so much review, the Dormaahene is being persecuted. Just a blatant attempt to remove the Dormaahene as a judge from the high and Nsem-Pii. And the NDC can say, and the Deputy Learned Attorney General, Yura Alfred Tuya Yabua, X-ray and Nsumu, F5.
I think there's no basis for anyone to think that this government may want the judge, who is also a distinguished paramount chief, removed from office. No. He made a comment. He made a suggestion. And that comment may either be accepted, or that suggestion may either be accepted or rejected. So far as we are concerned, the Dormaahene is an accomplished Dormaahene. He's also a sitting High Court judge. Nobody is been contemplating doing anything to him. But if within the space that he operates, there's a border may want to find out from him, that's another matter. But so far as the government is concerned, that interest doesn't even arise at all.
But I think the AG did comment after the Dormaahene statement that people should be careful in making prejudicial comments around ongoing cases, and that was interpreted to be an attempt to gag press freedom.
No, you can comment, but it was a caution. You can comment on pending cases, but your comments should not suggest that you are trying to prejudge that particular case, or you are making some comments indicting a judge. So I think that within the parameters within which the AG made that comment and a statement was issued. We have the right to pass comments. You can write commentary on it, but you make sure that you don't go beyond.
So where is too far? Because the former AG Ayikuto himself did say that he would advise the current AG to file a nolle prosequi.
It's an advice. It's within his remit.
So does that prejudice the matter?
No. Because that comment that he passed or he made, it was something, it was an opinion.
But people came out to condemn the Dormaahene.
That's another matter. That's what, so far as we are concerned, we don't even want to zero in on the paramount chief. No, it's about general comments. And we think that you can pass the comments. By in passing the comments, you must also have in mind that there are parameters within which you may have to stay.
Lawyer Alfred Chiayeboa, we no was setting the record straight. Quayson at Forson. Who's at Forson? So, he's been persecuted by the majority. The ruling government. After we actually petition Chief Justice, Justice get through to corner. Say, Judge Nikrano are presiding over the case, In fact, Yenino Enfa every so and some baby and a case at Forson. And then I'm working about 2.37 million financial loss to the state. The ambulance case. Say, and the Deputy Attorney General Alfred Chiayeboa, and so Ekasa Edifa, case at Forson.
Last time we were in court, the judge said that the petition had been sent to the CJ. The petition was filed by, I think, Sedu. No, the other person within, I think, one of the other accused, but the minority also has filed a motion. Tomorrow will be the day that will be in court. We don't know whether the CJ has reacted to that petition. So depending on what the CJ says, then we may want to know what we have to do. But nobody is persecuting him. In actual fact, his case started last year in court. And I may have to commend his lawyers also. The state has been able to call, we called about 5 witnesses and close our case. They've even opened their case and called 2 or 3 witnesses. So it's not about persecution, it's about rule of law. If at the end of the day, the court comes to a conclusion or determination that Atto Forson is not guilty, so be it, that's rule of law. If the court says he's guilty, that is it. So there's no inclination on our part to persecute him, no.
What about?
Yes, as I speak now, Mr. Atto ACN has not made the payments that he's supposed to be making.
90 million restitution.
90 million, he paid 30 million down payment. Then subsequently, he was supposed to have paid 20 million at the end of April. That amount, he's paid 8 million. And he was supposed to also be paying 20 million at the end of August and then December. So he has defaulted. We are supposed to be in court tomorrow. The last time we were in court, the judge said he was given the last opportunity to see whether he can redeem himself. So if, for example, we go to court tomorrow and he's paid, case ends. If he has not paid, we will insist that we are permitted to move the motion seeking to have him sentenced into prison.
But you are conflicted because I feel the AG's department wants to make a case that plea bargain is working. And this is a high-profile case because the prisons are congested. And yet, his inability or failure to pay undermines that.
I agree with you. You see, we thought that having taken advantage of Section 35, he will stick to his words. But he has not done so. So in future engagement with accused persons who may want to take advantage of Section 35, maybe we may also want to go another way. Because in this instance, you pay 30 million, we gave you 12 months. Having learned from this in a very bitter way, we may want to look at it again when you approach us with the same system to have your case terminated.